Host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Hey, good evening. I got to tell you that they have my phone number on the station's website if you go to the Ask the Expert show. Last month, we had some technical difficulties. And we had, oh my God, the phones were ringing off the wall. But that's what happens when you have a live show. I apologize for it, but I must have gotten 10 or 12 phone calls wondering what happened to the show. But we're here. We're here with our number one show from the number one law firm, K. Bender Rimbaum. They do community association law. So, and we've already got callers already calling in. Give us a call here at 888-565-1470. It's 888-565-1470. If you are a board member, property manager, you're a resident, you have a question, we've been doing this for almost 5 years now. And people love the show. So let me introduce you. This is the star. I'm just his sidekick. Let me introduce you to the star of the show. He is a board-certified lawyer, Robert K. from K. Bender Rimbaum. We got to keep our fingers crossed. No problems tonight.
Well, the weather's looking good.
Yeah. I can't believe all the people who called that wanted to know what happened to the show. It
was pretty crazy.
It was very crazy. So this is your show. We've got already somebody who's been waiting on the phone. Do you mind if we go to them first?
Let's
and then
do it.
We'll talk about the firm. Let's go to Jim in Boynton. Hi, Jim. Is Jim still there?
Jim?
I'm still here.
Oh, okay. You're live right now. Do you have a question for attorney Robert K.?
Yeah, hi, Robert. Hi. My wife and I have been in Florida a while, lived in an HOA, served on a board. We recently moved in a new community. And I just learned that our HOA excludes homeowners from running and serving on our HOA board if they put their home in trust. Is this legal? And if it is, are they no longer a voting member of the community they live in?
Well, there's provisions in Florida statutes that identify methods for trust-owned units to qualify to serve on the board. So unless there's something specific in the governing documents, which is unlikely, it sounds like there may be a bit of overreach going on and excluding people who are trust-owned property owners.
Okay, yeah, because I brought it to the board's attention, and they contacted a lawyer, and they said no, they shouldn't qualify somebody that has a trust. So I find that unusual.
Well, if you're interested in pursuing it, you may have to bring a qualified attorney in on your side to evaluate the documents and see if they have any true legal grounds to take that position.
All right, great. Well, thank you.
Thanks for listening.
Boy, I tell you what, no one's ever brought that up before.
Well, not on the show, but we've heard about it.
Oh, I'm sure you have, but I thought we'd heard everything. So
there's a lot we haven't discussed on this show.
Yeah, I know. So, we talk about we have new listeners every week, and let's just tell people about K. Bender Rimbaum, because you have such an incredible law firm that mainly works with community association, and a lot of people, well, when you say that, their eyes pop up. So tell everybody about
Well, there's
your
a lot
firm.
of associations in Florida, so certainly this is an interesting topic for most. But K. Bender Rembam, as you say, does concentrate in the area of community association representation. We generally work for the associations in providing legal guidance to all the needs that the association will experience in its day-to-day operations. It involves reviewing the governing documents, providing advice as to what the board can do, can't do, what owners can do or shouldn't do, pursuing unpaid assessments, dealing with contractors, negotiating contracts, addressing disputes, contract violations, defects to the community, pretty much across the board, every aspect that a community association will address, be it a small one or a large one. We have all kinds of those within our client base and our years of experience. We are made up in offices in Pompano Beach, Palm Beach Gardens, in Tampa, and we have a significant number of board-certified attorneys, which is a fairly small fraternity in the state of Florida. There's about 200 total, and in our firm, I believe we have about 9, and that's for the day-to-day legal work of all of our association clients.
You know, I have a question to ask you. I never realized. So you have an office in Tampa. We also
Yes.
have a show in Tampa. Somebody called us wanting to talk to your Tampa firm, and I gave them the number. It's the same number. The
Well,
Tampa,
you get
I
you
never
get the
realized
Tampa
it.
office by calling our main number at 800-974-0680. You can reach Tampa, you can reach Palm Beach Gardens or Pompano.
I was like, wait a minute, that's the number here. It's the same number. Anyway,
Technology, Steve.
unbelievable. So here's how our show works. You can either give us a call here at 888-565-1470. We are on 1470 AM, 96.9 FM, 95.3 FM, and we're on iHeartRadio. Or you can text me at 954-336-3767. Either way, we'll get your question on the air. We're also going to
And if
talk about,
anybody-
you got a lot of things.
Anybody
going-
wants to watch at home, they can go to our website at kbrlegal.com
That's
and
right.
watch it live there as well.
I got to tell you, you've got, because I see all kind of websites every day, you have got the most incredible educational website. There is nothing that you don't offer on your website.
Well, that's true. We have a tab called Resources, and within that is Rambam's Association Roundup articles, the legal morsel articles on interests of topical importance to our client base that's available to the public. You don't have to be a client to access that information. Just go to our website at kbrlegal.com. If you have an interest in attending any of our educational seminars, you'd also go to the website at kbrlegal.com and click on the calendar, see what events are upcoming, and click on that and make a reservation. Most of them are being done on webinars on the Zoom, so you do need to register in order to get access to them. Most of them have some form of continuing education credits. There are on occasion some that do not. For instance, December 9th, next Thursday, at the Broward Convention Center, there is a Cooperator Expo, and Michael Bender will be teaching a 2022 Community Association Legal Recap, which is not our normal legal update. So there's no educational credits for that, but it is a comprehensive overview of legislative changes that took place in the last legislative session, 2021, which they called 2022 recap. 2022 obviously hasn't happened yet. Many people out there are anxiously awaiting what kind of bills are going to be upcoming in the legislation in January. There's still a lot of things going on in Tallahassee and getting them into format. So there's a lot that we don't know yet, but it's something people should be keeping an eye on.
By the way, I've heard on the radio that event being promoted very heavily. So I guess they're expecting a big crowd there.
Yeah, Michael will be at 1:30 in the afternoon, but the expo is like, I think 9 to 4.
Well, if you've got a question here, you can call us at 888-565-1470. We're going to go to our text. I have a text from Jerry from Palm Beach. First of all, you'll love this one. Thank you for your show. I don't think you have any idea how many listeners you have. We have over 300 units, and most listen to your show every month. That's nice. My question is
hello to everyone there.
My question is about reserves. If the membership of an association reserves get wiped out, or what do you do with the reserve? Do you start off from scratch? And do condos have to have a reserve?
Well, let's break this down into the various components. Florida statutes requires that every year the budget that the condominium board will be considering for approval contains full reserves for various required components, being the roof, the painting, the paving, and any asset with a deferred maintenance in excess of $10,000. So that could be elevators, that could be something related to the swimming pool. So all of these have to have full reserves, and there's a formula that associations are required to engage to figure this out based upon the useful remaining life of the individual item and anticipated cost of replacement at the end of the useful life, and then divided by the amount of years left to go, and perhaps reduced by any existing balance that's already in that particular reserve account. These reserve accounts are all supposed to be kept on the books separately unless the owners vote to what they call pool them, which can be complicated, but then they all go into one fund, and there's other accounting rules that apply to pooled reserve accounts. The statute then allows, if the board chooses, it's not a requirement, the board can offer the owners to reduce the reserves on an annual basis, either to less than full reserves or no reserves. And unfortunately, as we've read about this year in particular, and have seen through the years, many communities routinely waive the reserves and don't have any, or have a very small amount. There used to be a requirement in the Condominium Act that the association undertake what they call a reserve study on a periodic basis every 5 years, but that was taken out some time ago, so there is no statutory requirement of a reserve study. It makes sense and is good business practice to do so at least between 3 and 5 years, bringing in outside independent experts to evaluate the issues that you're dealing with. You don't go to a roof contractor to figure it out. You go to more of an engineer, somebody who's not trying to sell you on whatever services they provide, and then come up with a estimated useful life and estimate for replacement costs. Obviously, replacement costs are going to be estimated at current values, and if you have an asset that's going to last 10 more years, you then have to somehow get to a number that you expect it might be in 10 years. So it's not an exact science, it's an estimate. So in this particular question, the individual indicates wiped out. So the way it gets wiped out is two ways. One is you use it for the purpose that it was being held. So you replaced your roofs, you used up all your roof reserves, you don't have any left. Or the owners vote to use it for a different purpose, which is also allowed by the statute. And so either case, you don't have any reserves, so you'd have to go with whatever the formula is for the remaining useful life on that particular item.
We got to go to break already. If you got a question for Robert, give us a call here at 888-565-1470. Robert, give everybody both your phone number and your website address.
Phone number you can reach us at is 800-974-0680. The website is kbrlegal.com, or you can send an email to info@kbrlegal.com, and that will get to the right person.
We're going to go to break. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back. This is the Ask the Expert show. We're with you every Thursday night, drive time, from 6 to 7, with, I say, some of the greatest experts in South Florida. Tonight's show, which we do the first Thursday of every month, it's K. Bender Rembaum. They're a community association law firm that people love. If you got a question, give us a call now at 888-565-1470. Robert, you have your calendar in front of you.
Well, I do, and unfortunately, December is the one month of the year where we don't have a whole lot going on, and I've already told you what's coming up in December on December the 9th.
Because the holidays.
We do have a couple of items in January that will be presented before we have our next show, so I'll share that on January the 5th at 12 noon on Zoom. We have a Lunch and Learn Town Hall with Sean Brown from our Tampa office, which is similar to our town hall sessions that you're so much in favor of, Steve. You've enjoyed participating in that. So it's basically a question and answer similar to this radio show, but it's more personalized. And then on January 6th at 12 noon, live on Zoom, condominium board member certification, which will be taught by Andrew Black, the certification for new board members, which will also have 2 continuing education units for managers. So those are the 3 items that we have upcoming. December the 9th at the Broward Convention Center, the Cooperator Expo at 1:30, and then the 2 Zooms January 5th and 6th. You'll find these on our website, kbrlegal.com, in the calendar. And then in January, we'll pick it up again with a lot more.
Okay, let's go to our phones. This Nancy in Boynton. Good evening, Aunt Nancy.
Hi, thank you for the opportunity to ask my question, and I appreciate the webinars and all of this information that you share. I was wondering if there is any kind of book or information out there for a home buyer when buying into a condo, I thought I had done all of my due diligence, looked at the financials and things like that when I bought into the condo I live, only to find out a year later when I'm on the board that it's a financial disaster. How do you even know how much is enough in a reserve when you're looking at reserves? What is the dollar amount needed or whatever? I thought I looked at numbers and thought they looked good to me, but clearly they did not. So is there any information for a homeowner before buying in?
To my knowledge, there is not any type of guidebook like you've described. It is a difficult concept for most people going into a condominium on their own without that kind of a guidance. And I guess it just takes some involvement with individuals who are a little more experienced in the area to help provide guidance, if it's an attorney or an accountant. An accountant would certainly be one who could give you a good idea if the financial picture seems appropriate. But the association has to be appropriately accurate in its accounting references to the reserves. As you've indicated, yours were insufficient. As I say, the rules that are established by the Division of Condominium do set forth a formula and a method of identifying the reserves for the unit owners, which includes the amount of the reserve account as of a specified date, the estimated useful life of each of the individual assets that are associated to the reserve account, and the estimated amount that it would cost to replace it at the end of its useful life. So you have a good idea, or should have a good idea from that, whether or not the reserves on hand are sufficiently adequate at the stage you are under the estimated useful life. So unfortunately, to my knowledge, there isn't any specific guidebook that I could point you to.
Well, maybe you can add it to your list of services.
That's a good
Well,
one.
every place is unique,
No,
so it's kind of hard
I would pay
to
as a new
create.
condo, as a condo buyer. If I go into a new condo, if someone offered that as a service, because I don't know what I'm really looking at, right? As a lay person, I would pay for that service for someone to do. Yeah.
We'll certainly keep that in mind.
Okay. Well, thank you.
Thank you, Nancy.
Thanks for listening.
You know, Robert, God, we got a lot of calls from people who own, I guess they're in towers, residents in towers that are very worried after what happened this year. They want to know who they should go to make sure that their building is okay and is secure. Now, that's an engineer, right?
Well, it would take an engineer to ultimately give you the most peace of mind, but the engineer has to be able to have access to everything, and sometimes some destructive testing is required. So it's not something an individual unit owner might necessarily have the ability to tap into on his or her own. So that falls to the board of directors of the association to oversee and make sure that that gets taken care of. I think it's safe to say that since the tragedy that happened in June, engineers and architects and experts of that sort are overwhelmed with work. So it makes good sense to reach out and try and find somebody qualified and get set up, even if it's on a schedule down the line in a couple of months, rather than waiting until it's needed and then not be able to find somebody. I mean, the market has gotten tight for all sorts of experts and hiring of various contractors. So that's something that people need to also be aware of when they're thinking about these things. The board does have a fiduciary duty to oversee the maintenance of the common elements of the building and to make sure that they're aware of its conditions. And this should begin immediately upon turnover from the developer, and oftentimes it kind of falls by the wayside. As buildings get older and the boards change and turnover and management companies change, a lot of things get lost. And that tragedy may have been the wake-up call that helps people get back on track to do what they need to do to know the conditions of their building. While it's good to be concerned, I don't know that anybody really has to be scared at this point, because it's such an unusual situation. But it is wise to get as much information as you can about your buildings.
We just got a text in. Somebody wanted to know, there's a lot of investors that are buying out a lot of the condos. Can investors be on the board?
If they're an owner of the unit, they certainly can. We've seen documents that indicate that only residents can qualify to serve on the board, but that runs afoul of the provisions of the Condominium Act that indicates that any unit owner is qualified to serve on the board, with the exception of somebody who has a delinquency in unpaid assessments or a felony conviction that hasn't been overturned for 5 years, haven't had their civil rights restored for a 5-year period, or anyone who's suspended by the division, which I'm not aware of very many people that fall into that category. So if they're an owner of the unit, then they'd be qualified to serve on the board. If they're a corporate entity, then they would be able to designate somebody from their corporation or LLC or whatever the entity may be to serve on the board. If they're a trust, the trustee often would be the one, or a beneficiary could be the one. It may require a couple with some kind of a residency requirement with the trust. But the documents have to be reviewed in each situation on those more unusual ones.
Let's go back to our phones. Barry in Miami. Good evening,
Hi,
Barry.
how are you?
We're good.
Hello, Barry.
Can a non-unit owner be a member of the board if the documents say that they don't have to be a unit owner? In other words, we've had several cases where there was a unit owner who sold the unit and then rented and continued on the board, or we've had renters who were long-term renters who eventually bought, but while they were renters, they also sat on the board. So I think you could have that situation if the document so provided.
Well, the way that the Florida statutes read is, unless the documents require ownership to qualify on the board, you do not need to be. So you'd be wanting to look to your articles of incorporation to see if there's any provision in there that indicates that to qualify to sit on the board, you have to be an owner. And if that language is not in your articles of incorporation, then anybody can qualify as long as they're over 18 years of age or aren't otherwise disqualified by statute, such as a convicted felon.
Okay, one other comment, if I may. There is a term called percent funded, and if the listener who asked about reserves Googles percent funded, does it matter? That is an excellent article that actually gives you it tells you what the term percent funded means, and that gives you a percentage of the accumulated depreciation on your reserve assets. And that's a term that reserve specialists use to determine how well funded you are. And the article goes through 3 different levels of funding. One is low funding, another's medium funding, another's high funding. But if you know that number, you can see whether or not your reserves are well funded or not. In other words, our reserves are 40% funded. That's not well funded. If it's 70% or more, that's well funded. If it's 40 to 70%, that's sort of like medium funded. And if it's 0 to 30%, that's low funding. But that is the term that reserve specialists use, and that's also a term that's in the National Reserve Study Standards. But that's where that person should go to see how well funded they are. There is a defined term and a way to determine how well funded they are. But they need to look at the reserve study and see what that percentage is.
Well, hopefully there is such a reserve study for her building.
Right. Thank you very much.
Okay. Hey,
Thank you, Barry. Thanks for listening.
Robert, give everybody your phone number.
You can reach Kay Bender Rembaum at 800-974-0680 or go to our website, kbrlegal.com, or email at info@kbrlegal.com.
We're going to go to break. When we come back, we have a lot of questions here. Hey, if you'd like to give us a call, we have a line open now at 888-565-1470 if you've got a question for Robert. We'll be right back.
Kay Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kay Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kay Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kay Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
And we are back. This is the Ask the Expert show. The first Thursday of the month, we have Kay Bender Rembaum. They're a community association law firm. And I got to tell you, we get so many texts and phone calls. And I got to tell you, there's a lot of people, board members, that aren't happy. Some of them aren't happy with the property management. And I got to tell you that we have one of the finest law firms on this show. They've been with us for over 4 years now. And you should really have, if you don't have an attorney representing your board, give Kay Bender a call. This is mainly what all they do. I know you do some title work, I believe, but it's
not these days. Not these days.
But anyway, give them a call.
It's probably 95% of what we do is community association.
And let me tell you something. I see them all. I see some of these firms that do bankruptcy and criminal law and personal injury and community association. It's much better to have a firm that really concentrates in one area. So I probably lost.
Being board certified, we can say we're specialists.
Oh, that's right. I can say that. So this is going to be a tough question. And I got a lot of questions like this. This is about the future for condos. And people are really worried because insurance is going up. Just the cost is going up. And also they are worried about new laws that are not going to allow you to waive your reserves. And they were saying it's really going to make it impossible for them. Can you tell them anything to put them at ease?
Well, I think it's a little premature to be jumping off the cliff worrying about what the legislature is going to do in the upcoming session. The legislative process is, if anybody's spent any time looking at it, sometimes it makes you wonder how they get anything passed, but it can be very involved and complex, and certainly there's a lot of politics going on, and various groups, interested parties are pulling the legislators in all different directions. And so what ultimately gets done, it's too soon to say what the effect is going to be. There's been talk about not being allowed to waive reserves, but that's unlikely to happen. I think there will be a mechanism to waive reserves, but it may not be as simple as it's been. I mean, it's been a majority of those who show up at a meeting, so that's a relatively small number. It might change to more of a supermajority of everybody, so it would take more of a concerted effort of the owners to do that waiver. There may be a limitation on how much you can waive or how frequently you can waive. You can waive for 2 years, but the third year you have to fund. That's just a possibility. I'm not saying that's actually going to occur. So it's really early to be worrying or thinking too much in terms of that. But there are many, many bills that are being considered, and I think that if you go to the Broward Convention Center next Thursday and at 1:30 go visit with Michael Bender when he talks about these things, as Michael is actually very involved in the legislative process, and he's involved with CAI and various lobbying interests for associations in Tallahassee. And he'll be talking about that at 1:30 next Thursday at the Broward Convention Center. If anybody wants to go listen to that, I don't believe there's a charge, so that's a good idea.
Well, we have a line open, 888-565-1470. We got a question that we've never gotten around the holiday times. Somebody put up their Christmas decorations too early and they got fined for it. Are they allowed to do that?
Well, I'm going to say they are allowed. They are legally allowed to do that, assuming that there is an appropriate provision in their rules that limits when holiday decorations are allowed to be up and for the duration and things of that nature. So if there is a provision in the rules or in the covenants that addresses that issue, and the board follows proper fining procedure, which requires advanced written notice of the violation and an opportunity for a hearing that would be before a separate committee of unaffiliated owners from the board, and then they approve the fine, then yes, that could happen.
Okay. Phone number here is 888-565-1470. Jim from Palm Beach lives in a condo. He's a board member, and we're going to be, I guess, repaving their parking lot. And he wants to know about if they're restriping, what about handicapped parking for a condo?
Quite typically, when parking lots get repaved and restriped, the current code then becomes effective, and whatever the current code requires relative to handicap parking and other limitations would then come into play. If they were not doing restriping and everything was staying the same, they're just doing repairs to their parking, that would not kick in such a requirement of retrofitting to meet the new code requirements. But in the situation described, in all likelihood, did he say what city he's in?
Yes, Palm Beach. Well,
that's in the county, but some cities are more inclined to do that than others. So you check with your local municipal code to determine that obligation.
We also had a lot of people wanting to know, how many bids do you have to do? This is for
The statutes require competitive bids without setting a number. So if you have more than one, that's competitive. However, if you can't get more than one, because in today's market, finding a contractor to give you a bid is iffy at best. So to get multiple contractors to do it sometimes becomes even more of a difficult prospect. You have to make the effort to get competitive bids, and if you're able to more than one, three is considered normal, but if you only have two, that's still competitive. If you can only get one, but you made the bona fide effort, that will also satisfy the requirements.
Here's Jack in Boynton wants to know if the association can come in to his residency without his permission.
Did he say if he's a condo?
He did not.
Okay, well, if it's a condominium, the statute does allow for access under certain situations, which would be to protect the common elements or other unit owners from damage that might be emanating from the unit after a reasonable effort to have permission. HOAs would likely be more within their documents whether or not the association has such an entitlement. So it's possible they do, but it's also possible that they do not. And they don't have the right to just come in whenever they want. There has to be the appropriate need for it and an attempt to get in with permission first.
What do people? We got a lot of people who wrote us about campaigning door to door because they have no soliciting signs. Are they allowed to do
is
that?
Is the campaigning for their internal board seat,
Yes.
or is it campaigning for regular politics?
Their board.
Well, that's not soliciting. So there is no legal prohibition to that unless there's something specific in their own community documents that does not allow for that. Other than soliciting.
This was a condo, by the way.
That would be legally okay.
Okay. Had a lot of also letters about people wanting to know, like here's a property manager. This is a condo. It's a property manager runs our meetings, and towards the end unit, owners, end of their meetings, people were allowed to ask questions. She just announced she's not going to allow questions and answers anymore at the end. So what do we do to get this into meetings when people have questions? Can she stop us from asking questions at the end of the meeting?
Well, under the condominium statute, unit owners have the right to attend and participate in meetings of the board. And participation means the ability to address each of the agenda items, and the board is allowed to make rules that will identify how long they can take for each particular question. It's considered a 3-minute limit, but it's not in total, it's per issue. And when it happens during the meeting, some communities will set it up at the beginning. Some will allow for it in the middle as they're addressing each of the agenda items. Some put it at the end, as this one had done. There's pluses and minuses to both, or all three of the choices, but the option to not allow it at all doesn't exist. If this owner should contact individual board members and see, because the manager doesn't run the place, the board does, and the manager has to follow what the board desires. If that doesn't work, they may need to contact the Division of Condominiums to identify this statutory violation and see if the division would then get involved to further address it with the manager and the board directly, which could resolve it, could end up getting the community a fine for the violation if they persist, or they may want to just get their own attorney to try and address it directly.
Mary in Delray wants to know, this is regarding the ADA compliance. They're in a 300 plus HOA community. She wants to know about sidewalks. She said, "We have no sidewalks. How do we get them to put sidewalks in?"
Well, first off, for a community of that nature, the ADA, or Americans with Disabilities Act, does not apply.
Okay.
Only Fair Housing Act. And there isn't anything specifically in the Fair Housing Act that would compel the association to put in sidewalks. If somebody has a particular disability affecting their use and enjoyment of their own property that may need the installation of something like a sidewalk over a certain portion, they can make a request for reasonable accommodation, which the association would most likely have to allow. The installation would be at the owner's expense, not the association's. Other ways to compel in putting in sidewalks where they don't exist, you would have to review the documents to see if there's limitations on the ability of the association to undertake a capital improvement of this nature by a vote of the board alone, or if it takes a vote of the owners to accomplish putting something in where it doesn't currently exist. That would be the capital improvement side of it, as opposed to maintaining or fixing existing aspects of the community, which would not be considered a capital improvement or a material alteration as it applies in condominiums. So that those are the options, and then take that to the board. If the board's unwilling and there's enough owners that want it, you work on addressing changing the board. Petition signed by the owner sometimes may work, sometimes not. If the board's intransigent or doesn't want to spend the money or get involved in it, then they would need to address it at their next election or through the recall process.
Let's go to our phones. Steve in Sarasota. Good evening, Steve.
This is my question. There is currently a three-member board in our sub-association, and we're having elections. Now, one of the members owed money for assessments right at the last on the last day after they put in their form for to be a nominee, and they paid it a day or two later. Does that disqualify the person?
Were they included on the ballot?
Were they included on the ballot? Yes.
Well, once
people that haven't paid right at the moment due.
now, Steve, did you say this was a condominium?
Condominium, yes.
Okay. And do you know how much assessments were outstanding?
Well, it was somewhere between $375 and $3,500. And the reason for that is because
$7,500.
the reason that it would vary so much is because there was a new assessment to the owners in the particular building for new windows. So the new windows was like at the beginning of the month, and the cutoff date was at the end of the month. So they owed money for that, as well as some other monthly, maybe one or two monthly assessments.
Well, if this individual was delinquent on the date of the eligibility for putting his name in to be a candidate, he should not be included on the ballot because he didn't qualify. By paying it off and having been included on the ballot, it's possible the division would view that as curing the issue before the actual election. and then allowing it to go on. Now, if he's on the ballot and the ballot's already been sent out to the rest of the owners, the options would be to challenge the election by including this otherwise disqualified owner because he wasn't eligible at the required time. And you could take that through arbitration or to the courts, since arbitration is now no longer mandatory. Or you certainly can send a letter to the board indicating this individual should not have been on the ballot and needs to be removed. And they could either reset the meeting, or if there's time to send out new ballots, they could fix it that way.
Okay, this is a little bit more involved in that I am actually on the board with this person. The person is also currently on the master board, which also has elections. So what happened was on the same date, or approximately the same date, was the cutoff date. They technically, I guess, would be disqualified for both. Now, the master board...
Is the master also a 718 master, or is it a... Okay.
718.
Well,
so
to be disqualified as a director, the delinquency has to be for more than 90 days.
Okay.
To be disqualified to run, it would just be any delinquency as of that date.
Okay. What happened was the master board moved their election date forward about a month or more. So what happens is they're now able to take new applicants. So does this person, if they put in a new application, even though they weren't qualified on the first round, are they qualified on the second round?
If they're opening it up to new candidates and he's no longer delinquent, then yes, he'd be qualified.
Okay.
Sounds like he's got some pull.
Okay.
Thank you so much, Steve, for calling.
Good luck with the election.
Hey, let's give everybody the phone number at the office.
You can reach us at 800-974-0680. You can write to info@kbrlegal.com or just go to the website, kbrlegal.com. There's a form you can fill out if requesting contact, and someone will get back to you that way.
Well, I got to tell you, we love having you on every month. You're on the very first Thursday of the month for the entire hour, 6 to 7. The name of the firm is K. Bender Rimbaum. And I know this show, just by reading all these letters, how much help this show brings to people. Robert, I won't see you again. Happy Hanukkah, by the way.
Thank you. Same to you. And happy holidays for the rest of the season. Happy New Year. We'll see you next year. Looking forward to all the calls we get next month.
Okay. Have a good one. Happy holidays. And we will be back with you next week with more Ask the Experts, 6 to 7 every Thursday, 1470 AM, 96.9 FM, and 95.3 FM. Everybody have a wonderful week. We'll see you next week.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lort of Lort Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.